I'm going to hand over straight to Celia, who is going to give us an introduction into immigration detention in the UK, including the powers of the Secretary of State to detain, as well as immigration bail. She'll also provide us with a quick whistle-stop tour of BID's history challenging immigration detention. So over to you, Celia.
Thank you, Imogen, and any apologies in advance for any technical problems, which will not be down to me, of course. Thank you for inviting us, and thank you for dedicating this session to such an important topic. You know, I'm going to, as you said, introduce just briefly about immigration detention in the UK, and then a bit about BID. And hopefully the three of us will cover different aspects, because Pierre's going to talk about how we've managed to effect change through strategic litigation, and Adam's going to be doing dispatches from the front line and what it's like to be there in detention supporting people, and also what it's been like since the pandemic. Because it seemed quite appropriate to have that title of indefinite lockdown, because people can relate, people who haven't been in immigration detention can relate to some degree to what it's like in a very small way to be detained, from having been forcibly confined to their houses. I mean, obviously that's very, very different from being in immigration detention. But we thought at least, you know, there would be a link for people to be able to relate in some way. So what is immigration detention in the UK? Well, it's the process of incarcerating people who are subject to immigration control. And the law permits the Home Secretary to detain people if she is trying to establish their right to be in the country and or to effect their removal or deportation. So the Home Secretary has the power to detain someone, but that power is limited. And the limitation of those powers are mostly found in what's called the Hardiel-Singh principles, which are called Hardiel-Singh after the person who brought the challenge to immigration detention way back in 1983. And so those principles set limitations on the Secretary of State's power to detain. So in order for detention to be lawful, there are four principles. The first one is that the Secretary of State must intend to deport the person and can only use the power to detain for that purpose. The deportee may only be detained for a period that is reasonable in all the circumstances. The third principle is if before the expiry of the reasonable period, it becomes apparent that the Secretary of State will not be able to effect deportation within a reasonable period, she should not exercise the power of detention. And finally, the Secretary of State should act with reasonable diligence and expedition to effect removal. So that's how it works. In practice, someone is detained usually with a piece of paper called an IS-191, which is given by an official from the Home Office. And that decision to detain that individual is not sanctioned by a court. So there's no judicial oversight of the decision to detain. And even more shockingly for those who aren't familiar with detention, there's no time limit on detention. So you've already got two very, very important safeguards that don't exist in terms of immigration detention in the UK. The result of that is that people can be and have been over the years detained for days, weeks, months, and even years. I've been at BID for 15 years, and in that time, the longest detained client that we've had was detained, not imprisoned, but detained under immigration powers for 5 years. And the longest that we know of, which the HM Inspector of Prisons found, someone in a prison who'd been detained for 9 years. So if you extrapolate that in terms of a prison sentence, the 5-year person, the 5-year detained person, and actually we had more than one who was detained for 5 years, was the equivalent of a 10-year prison sentence. So, you know, that's pretty shocking stuff. The other thing to say is that detention centres are like prisons. The ones in Heathrow particularly were built to prison standards. You know, they have a central well with corridors like you see in the movies. And your movement is restricted. People in the past have talked to us about simple things like not being able to eat when you want to. You have to eat at certain times. You're locked in and out in certain times. So you can imagine the effect of that, you know, the shock, first of all, of being detained, because it's not a criminal sanction, it's an administrative sanction. The fact that it carries on, sometimes for years, and you don't know what to do about it. Now, people who are placed in detention are supposed to be given information about their rights, and in particular, the right to apply for bail. So the main route out of detention is to apply for bail, and that's where BID comes in. But a lot of people don't know about their rights to apply for bail. And although, as I said, as part of their induction, they're supposed to be told that they have the right to bail, you know, there's lots of people who really don't know. So, you know, it's very much about an individual having the wherewithal, having the knowledge to be able to inform themselves about their rights and exercise their rights. You know, there's no automatic bail hearing, although within the last year, the Home Office has instituted a system of automatic bail hearings after 4 months detention. But it excludes anyone with a criminal conviction, first of all. And the system hasn't been working at all anyway. So you can see that people can be left for a very long time, and it's, you know, the effects of detention long term have been documented, well documented, and, you know, it's quite unimaginable that we do that in this country, and that we have a process that incarcerates people just literally because they've crossed a border, or, you know, they're subject to some sort of legal case that wants to remove them from the country. And just to give you an idea of the scale, in 2019, there were 24,443 people detained in the UK. Adam's going to talk about post-COVID, because things have changed, and I don't want to sort of say too much about that now, because I'm really reflecting on the whole picture of immigration detention. And so just over a year ago, in June 2019, there were 1,727 people. So the Home Office does snapshot figures of how many people are detained at every quarter. So there were 1,727. And at the end of May this year, that had fallen to 313. So quite significant. So BID has been around for 21 years. And it was established by a group of activists who, at the time, I mean, obviously, you know, 21 years ago, things were different, but not so different as well. But this group of activists in particular felt that, well, first of all, they were shocked that people could be detained. And bear in mind, people were detained in very, very much lower numbers than they were subsequently. So it was in the hundreds rather than in the thousands, as it subsequently became. But so at that time, they really felt that this was something that could be challenged. They felt very optimistic because it was a new Labour government, relatively new Labour government, that had been in charge for just shy of 2 years. In fact, the first group started BID in 98, but it became a charity in 99. And they thought, well, you know, we're going to get everybody out of detention, so we're just going to churn out bail applications and release them. And at the same time, we're going to do policy work and research, and we're going to convince the government that you don't need immigration detention. So that was the idea. But that combination of research, policy, advocacy, and the legal casework was at the heart of what BID does. that was how it was set up, and that's something that we've remained true to ever since. So we aren't just about getting people out of detention, important as that is. We're about trying to change the system that keeps them there. So our overall aim as an organisation is to end immigration detention in the UK. Of course, that's not in our gift, but everything we do contributes to that aim. And so we're trying to achieve change. That is our sort of very broad, you know, motherhood and apple pie aspiration, if you like. But underpinning that is change in detention policy and practice. So we sort of chip away at detention policy and practice, and have done throughout the years. And you can all have a look at our website if you haven't already. I'm sure you have, and you'll see sort of all the research reports we've done over the years and the different focuses. But always the focus of our policy advocacy emerges from our casework. We have to be able to evidence what we say, and they have to reflect the concerns of our clients. So, you know, we draw on our clients' experiences for our evidence, and we're able to say with authority what's happening in detention. So that's really important for us. And I'm just going to illustrate it. I've got enough time, Shanzeh, have I? And Imogen, yes?
Yeah.
I'm just going to illustrate how we effect change and have effected change through the years. And I think the best example of that was in children in detention. In 2001, we started a project to support families in detention, because at that time, children could be detained on the same basis as adults, unbelievably. So there were lots and lots of families who were being detained, parents and children. And again, there was no time limit, no automatic bail hearing. And so BID started working on this in 2001 and just produced reports about the damaging effects of detention on children, on their parents, and we set up, so we're a very small organization, very few resources, you know, from about 2001 till about 2006, we seem to be the only organization working in this area. And in 2006, we went into partnership with Save the Children Fund and the Refugee Council to mount a public campaign, which was called No Place for a Child. And those organizations had obviously thousands of supporters, and there was a postcard writing campaign. And I think that was the moment at which the whole issue of detaining children gained prominence in the UK, where it hadn't really been, people didn't know about it at all. And, you know, despite our best efforts, we couldn't get that public profile to it. And then in 2008, I think it was, we entered into a formal partnership for which we were given funding to work with the Children's Society. And again, that was a big organization with a reach, you know, far beyond anything we could have dreamed of, with its own parliamentary department, with its own policy department, with its own media department. And we really benefited from that public profile that that partnership gave us. And one of the things that they were able to do was to attend the party conferences, and BID and the Children's Society spoke at the party conferences. We published research, and during the party conferences, the Lib Dems adopted ending the detention of children in their manifesto. And at the time, I have to say that we were sort of slightly dismissive about it because we thought they'd never get into power. But, you know, we're pleased as well. And there's also been some lobbying of the Tories, who at that time were not in government. And the surprising thing that happened was that in 2010, there was a coalition government between the Lib Dems and the Conservatives. And one of the first announcements they made was to end the detention of children. And I think it was something that we'd worked towards but never really expected. And I think drawing from that example, and of course now children in families are still detained, but only for 72 hours. So we kind of didn't didn't get everything that we wanted, but the situation was so much better than we had ever anticipated. And I think sometimes there are unintended consequences of what you do. So you do all this work, you provide the evidence, sometimes you feel like you're doing it in a bit of a vacuum and that it's not going to make any difference. But sometimes when you least expect it, it makes a difference. And I think what I haven't touched on, and Pierre is going to talk about, is our strategic litigation, because we started off just doing bail, research, policy advocacy, and so on. And through the children in detention, we began our strategic litigation, which was referring clients for unlawful detention claims, but also starting to act as interveners in really important cases that focused on different aspects of immigration detention. And that was something that Pierre spearheaded really when he came to BID, and has been a really important part of BID's work. So I think in summary, we are about, first and foremost, getting people out of detention, but we want to end this pernicious system. It's not okay to keep people locked up for the purposes of immigration control, and it will never be okay as far as we're concerned. So, you know, that is still our overall aim. And with 313 at the moment and everybody working like mad to get everybody out, who knows what may happen. I'm going to stop there.
Great, thank you very much, Celia. That was really, really informative. And I think what you touched on highlighted a number of rather worrying aspects which come into play when it comes to immigration detention in the UK. For example, the lack of safeguards in the form of judicial oversight to detain, the lack of time limits. But on a positive note, having organisations like BID who support detained individuals and more widely challenge detention policy is, in one sense, very reassuring, because, as you said, a lot of detainees aren't told about their rights, and that can obviously have catastrophic impact for them. So I'm now going to hand over to BID's Assistant Director, Pierre, who is going to tell us more about BID's involvement in strategic litigation, as Celia mentioned just now.
Thanks a lot, Imogen. I've got 10 minutes, haven't I? That's right. Yeah.
15.
15. Okay, good. When I first turned up at BID, what had happened most recently in the previous Christmas, I arrived in September, was that there had been disturbances at Harmondsworth Detention Centre. And on the day of those disturbances, which went through the night, BID was contacted by detainees. We telephoned the police. We contacted the emergency services because of the way that detainees were being treated. Seemed that they were being put at serious risk. Subsequently, while I was there, some of the detainees took a claim against the Home Office, in fact against Calix Limited, who were the people running the removal centre, on the basis that there should be a public inquiry due to an Article 3 violation. That's inhuman degrading treatment in particular, during those incidents. We then decided to apply to intervene. And the reason why we thought, and the case was at the Court of Appeal stage, and the reason why we thought that it would be a good idea for us to do so is because we had been involved on the night. So we had evidence that would contribute to a witness statement. And we also had, and this happens throughout all the work that we have carried out on strategic litigation of any kind, all our interventions, and there have been many, what we had was we had tremendous support from barristers and solicitors acting pro bono, so that we were pooling our knowledge on detention and immigration with public law lawyers. In fact, in that case, and with many of our cases, they're commercial firm public law lawyers at Allen Overy Solicitors, who I've learnt over time the courts like a lot, and also barristers who are specialised in immigration law and detention law, and public law lawyers who had many years of experience. And that came together to really drive forward our own submissions, and finding that, in fact, in that case, that the government had taken too long in establishing an independent public inquiry, which should have happened. That was the declaration that was eventually achieved. Nevertheless, it taught us a lot about how to work with lawyers and how to work with the courts in terms of being an intervener. A subsequent case that followed soon after that was a case called SK initially, but then called Shepherd Kambadzi, who was a Zimbabwean man who was taking a case on the failure of the Home Office to carry out independent reviews of his detention. And in order for us to apply to intervene in that case, we of course explained our own expertise to the court of being specialists in immigration detention, but we also conducted reviews of Home Office files. We obtained files under the, which are called subject access requests, Freedom of Information Act in individual cases, and we obtained about 10 case files. They were very large files, and spent an entire weekend reviewing them and looking at when reviews had been conducted by the Home Office and the standard of the reviews as well. And that contributed to evidence in a witness statement, which actually subsequently also contributed to evidence in a related case called Walumba Lumba. Lumba's case is extremely important in reaffirming various legal principles, and I don't want to go into too much detail, but for those lawyers who are watching, the Harjil Singh principles. And the evidence carried a lot of weight, but at the same time, we had senior counsel helping us on that case, Michael Fordham, QC, who's now a Deputy High Court Judge. And we had an excellent team of barristers who worked with us, in particular Laura Dubinsky from Doughty Street, with whom we've developed a fantastic relationship. And that case, I think, with the Supreme Court, established our reputation as being what is absolutely essential for an intervener. Participants in a case that will contribute an objective body of evidence, albeit the fact that we represent a particular point of view, meaning that we act in the interests of detainees. We believe in ending the use of immigration detention. However, our work is founded upon evidence. And another good example of how we have been able to use evidence and looked for evidence through our casework in particular is the case of Chiari and Bindlos, which related to the out-of-country appeal system, where the Home Office was able to deport people who were non-EU nationals prior to their appeal hearing or during their appeal hearing, and for that person to then conduct their case from abroad. We decided to participate with the tribunal in enabling one of these cases so that we could investigate the obstacles to a case. So we had a Nigerian man who had been deported to Lagos, and we corresponded with the tribunal. We had to buy computers, we had to buy a projector, we had to bring our own speakers, we had to enable and facilitate everything. This is despite us engaging with the court about this. And we were also able to show the obstacles that we faced in trying to take instructions long distance and prepare a case. And the court then referred directly to our evidence, the Supreme Court, to our evidence and the obstacles we faced in finding that the out-of-country appeal system was unlawful in that case. And since then, the Home Office has continued to try and find ways of making it lawful by equipping the relevant parties to a case. But we remain in a situation where I think the ultimate finding in that judgment is that it's extremely difficult, if not impossible, for there to be justice with an out-of-country appeal. I think one of the questions people might have in their minds is, why intervene and not take a claim against the Home Office? I think that that's partly because we're in this in the long term, for the long haul. Unfortunately, we know that detention has not ended and it's unlikely to end very quickly. We know that we need the respect of the court in order to be heard loudly and clearly. We've gained a good reputation with the court through the initial interventions. That means that the court will take our evidence very seriously. And we found that the impact of our interventions can achieve as much as acting as a claimant. That's not to say that we won't act as a claimant, but it does mean that when we consider whether or not to act as a claimant, we're careful about the decisions in that regard. So we have been looking and exploring at taking certain claims. The cases have settled, but it's a calculation that we're very careful about. The other issue is, of course, costs implications. It's easier to get a cost protection order when you're acting as an intervener, and it's a greater risk when you're acting as a claimant. The world is, however, changing, and there were changes made in 2015 with Section 87 of the Criminal Justice and Courts Act, which brought in new rules for interveners, rules that requires the court to make a cost order against an intervener in certain circumstances. And those circumstances are really where an intervener has acted in place of or in order to support a claimant, or where their submissions have not had direct relevance to the issues raised in a case, in the particular case. I think that we've not had problems in meeting those requirements because that's how we've always acted anyway, prior to that legislation coming into force. But it does raise more concerns. And for example, at the moment, we are considering an intervention where we are applying to intervene in a case where we have previously provided evidence. The case has been evidence before the independent funding adjudicator, which relates to refusal of legal aid, and subsequently to the applicants. However, as permission has been granted, we've discussed the issues with our own counsel, and we feel that we have certain issues that we want to contribute to the court and to make our own submissions. And that means that we have approached the parties to indicate that we intend to apply to intervene. Now, how this is going to play out, we will see. I think that, having provided evidence in support of the claimant before makes me extremely cautious, and I want to see how the parties to the case will relate to us, and certainly how the judge will consider our submissions. But if we lay our cards open to the court and make it clear why we're intervening, make it clear even our concerns to ensure that either side will not see costs against us, I think that should allow that should allow us to proceed in confidence that we won't have costs sought against us. But it is a calculation. So at the outset of the case, you need to be thinking, why is it that we're applying to intervene? What is it that we have to contribute? And, you know, bear in mind that the other large amount of work that we do and significant amount of work that we do is to contribute expert evidence. And our expert evidence also arises from our casework. It has been significant in recent cases in contributing evidence in relation to claimants who are taking claims against detention under immigration powers in prisons. It's been also significant in claims about accommodation provided by the Home Office, case of Sananthanam, and in a more recent case where the issue of the provision of accommodation under Schedule 10 of the 2016 Act has been the central focus of the case. So expert evidence on its own can have a huge impact. The higher you go up in the courts, the greater the need really to be focusing upon what you can contribute from the point of view of legal argument. The government legal department has tried to argue in a couple of cases that the cases relate solely and wholly on legal principles and legal issues which are unrelated to our work. That's where I think we've been able to argue very well against the Home Office on the basis that our work is formed by, is dependent upon barristers and solicitors providing us with pro bono help. We specialise entirely on detention. We have the expertise of barristers and solicitors who focus solely on detention to be able to contribute meaningfully on points of principle relating to public law and detention, or relating to just immigration-related issues on detention as well. So on a final point, I should say, the Home Office increasingly seems to object to our interventions, and I think that's because our interventions have been treated with the respect that they demand and hopefully will continue to demand of the court. And while the Home Office has become more strident in objecting to our interventions, I think the courts have tended to become more favourable, and that I think is probably the result of very many years of work. That's it on me.
Thanks very much, Pierre, in highlighting the importance of interventions and also the strategy behind it. We're now going to turn to our final speaker, Adam, who is one of BID's caseworkers. Adam is a legal manager for the Right to Liberty team, and he assists detainees who are often the most vulnerable individuals in detention centres who have often been detained for a substantial period of time. So I will hand over to Adam now. Thank you.
Thank you, Imogen. I've got quite a broad range of topics to get through. So it's quite difficult to kind of pitch this talk because I don't really know like the level of knowledge some people have got. So I apologise if it's kind of not too detailed for some people or not detailed enough for others. But my name's Adam. I'm an immigration solicitor. I'm one of 4 legal managers who work at Bail for Immigration Detainees. You've heard a little bit about our policy work and our strategic litigation, but what I'm going to talk about is the bail applications that we make. I kind of think of it as though the policy work and the strategic litigation is slightly more glamorous, if you like. It you know, kind of might get more attention in the press and things, but a huge amount of what we do is just churning out bail applications, and I'm like hugely proud of the number of people who we managed to apply for bail for. So my job essentially is to do legal casework on immigration bail matters. So there's me and there's 3 other legal managers, and in normal times what we do is we manage small fantastic teams of volunteers, and under our supervision, and in fact a number of our volunteers have joined us this evening, I noticed, so thank you very much. I hope you're all well wherever in the world you are. We have small fantastic teams of volunteers, and under the supervision of legal managers, we simply prepare as many bail applications as we can. Excuse me. Now at present, because of COVID, we don't have any volunteers working for us. So we've got a situation where me and the other 3 legal managers are kind of stuck in our respective bedrooms across London, but we're still trying to churn out as many bail applications as we can. And I think that, like, what I want to stress about this work is that it's our job to try and use the kind of legal routes available as they are to secure the liberty for as many immigration detainees as we can. So how do we do that? Well, the process for applying for immigration bail is relatively straightforward. There are 2 types. I'm not going to go into a huge amount of detail. There are 2 types of immigration bail application. There's an application that you can make to the Home Office, but given that the Home Office is the organisation who've made the decision to detain, have maintained detention, and presumably at the point the person is asking to be released are currently in detention, so the Home Office haven't used their discretion to release them. It's not surprising that in my experience, applications for Home Office bail are very infrequently successful. And so what that means is that the vast majority of the work that we do is aimed at the tribunal. And importantly, and as Celia touched upon, although the people who we're representing at this point have been denied the right to their liberty, it's very unlikely they wouldn't have had any judicial oversight until the time they first go into their immigration bail hearing. So briefly again, the way that we prepare a bail application, there's a particular form that needs to be sent to the tribunal. The tribunal will respond to us and they say that you've got a hearing on X date, usually 3 or 4 days after the form has been submitted. And then in that time, myself or my team, and we've got volunteers, are working frantically hard to gather as much evidence as we can and to draft the legal grounds in support of that bail application. I can't go into detail about all the different sort of types of evidence that we can get, but I think it's, you know, it's sufficient to say that in as much as no 2 people's lives will be the same, sort of no 2 bail applications will be the same, and each bail application needs to be prepared specifically in relation to that individual's circumstances, and so it's, you know, you need to look at what you think the Home Office are going to say against bail and then prepare and gather evidence accordingly. We are very fortunate that we've got fantastic relationships with a number of barristers' chambers. So we have some really fantastic advocates. We have QC sometimes who give their time pro bono to represent our clients in the first tier tribunal. And you know, I think that's part of the reason that we are as successful as we are. I've said that each bail application will be dependent on its facts and will be specific to that case. But just to say briefly that there are a few topics which will always come up, because remember the stated purpose of the Immigration Removal Centre is to remove the person, and so the judge will first and foremost be looking at, can this person be removed? If there's a legal barrier to their removal, whatever that may be, that will obviously work in their favour, in favour of release. The judge will also look at the likelihood of that person doing what they're asked to do if they're granted bail. the likelihood potentially of them offending, of them committing crimes if they're released, and also, although probably not as frequently as they should do, the judges will look at any vulnerabilities that that individual has or any other compassionate circumstances. So, you know, as I say, we haven't got very long today, so I can't really give an exhaustive list of all the types of evidence that we can gather, but that volunteers who are participating will be familiar with the sort of documents that we try to obtain. So that's in a nutshell, that's what I do with the other legal managers. And again, it's kind of too many challenges to list as well. But so what I've done is I've kind of tried to identify two key challenges that I think we face. And I will rattle through these. The first challenge that we face, which is unfortunate, is that we are a small charity. Like I said, we've got 4 legal managers, and the demand for our services vastly outstrips what we can supply in normal times. It's not quite true at the moment because the immigration detention estate is so much lower because a lot of people have been released as COVID, but certainly during normal times, we are approached by many, I mean, I don't know, maybe last year we represented somewhere more than 2,000 individuals. But we're not in a position to prepare 2,000 bail applications with the 4 legal managers and volunteers that we have. So the way that we manage this problem is that we have a self-help sort of service for those people who we think are most able to represent themselves. And then we have dedicated teams which are directed and focused on representing individuals who might have particular hurdles to overcome to apply for bail. And again, to go through those quickly, we've got a prison team because although immigration detention is for the purpose of facilitating removal, and you might associate in your mind prison, the purpose of that might be punishment, it is legal to detain people under immigration powers in prison. And those people face barriers to being granted bail that people in immigration removal centres won't. So briefly, they haven't got mobile phones, they won't have any internet access, they will be locked up for extended periods, there aren't immigration solicitors who are periodically going into the prisons. So one team we have is a prison team. We have a separated families team because immigration detention doesn't just impact on those people who are deprived of their liberty, it also impacts, you know, British children and wives, and non-British children and wives, and their rights and feelings are too infrequent and not sufficiently factored into the Home Office's decision making, and the idea that a child can be separated from their father or mother for administrative convenience to uphold immigration laws is, you know, something which I think a lot of people find quite difficult to stomach. People thinking about their relationships with their own families, and so we have a specialised family team who deal separated family team who deal with those individuals. And then the final team that we have is a team that I and another legal manager co-manage, and it's called the Right to Liberty team. And what we try and do is look at people, so there are people who aren't in prison and people who haven't got kids that they're separated from. And then amongst all those people, we try to identify those who are least able to represent themselves. And then we give them the most support that we can. So reasons that someone might need particular help might be because they've experienced trauma as a result of being a victim of trafficking, modern slavery, people who have experienced torture, people with serious mental or physical health issues, learning disabilities. And what we try and do is identify those in the greatest need of help and represent those people. For people who aren't familiar with immigration detention, it might be shocking at all that people who fall into those groups that I've just listed are legally able to be detained at all. Unfortunately, it is my experience and BID's experience that those people are detained all too frequently. And that brings me on to the next challenge which I wanted to discuss in this kind of rattled through tour, which is poor decision making by the Home Office, poor systems which are in place, and I might even go as far as to say bad faith on behalf of the Home Office. And I think that COVID is a really good example of this, because the pandemic has kind of shone a light on a number of failings in our society, and immigration detention is no different. So, as Celia mentioned earlier, as a result of COVID, the immigration detention estate population has dropped quite dramatically. And that's not surprising when we remember, again, that the stated purpose of immigration detention is to facilitate removal. And as a result of COVID, you know, there are flight bans to a huge number of countries, and the number of outgoing flights is massively reduced. People can't be removed, ergo they should not be detained. And the Home Office's response to that was to conduct detention reviews of every single person who was detained under immigration powers in light of COVID, and come to a new decision about whether or not their detention should be maintained. And it's interesting that since lockdown, we've done 138 bail applications, and 125 of those bail applications have resulted in grants. So I worked it out to be about 90%. The vast majority of those 138 bail applications would have been conducted after the Home Office have conducted an independent review of that person's immigration detention in light of COVID. Okay, so the Home Office has done their review, they think the detention should be maintained, and then those 138 people contact us, we apply for bail, and in 9 out of 10 cases, the independent judiciary has agreed with us that detention isn't appropriate, usually because removal isn't possible. And I think it's, yeah, often with working with the Home Office, I have this saying where I say that I am frequently shocked but not surprised. And this is exactly what we've seen in this experience. I'm not surprised that the Home Office maintain people should be detained when clearly, you know, the legal basis of that is very dodgy. Well, I am shocked, but I'm not surprised. It's not surprising that the Home Office do continue to make terrible decisions, because that is something which is consistent with my dealings with them. And I think in the time we have, I've got a 1 minute warning, but I suppose just to conclude there, I think that part of the problem with the Home Office is there is this hostile environment message which seems to come out from the top, and that seems to kind of trickle down, and there is a endemic culture of disbelief and sort of callousness, which is clear in their decision making across the board. So in their decisions to detain people, in their decisions of entry clearance applications, in their decisions in asylum claims, and I sadly don't really see that getting any better anytime soon. And that's part of the reason why I think our work is so important. Thank you.
Thanks very much for that, Adam. I think we could have continued to listen on and on and on. Unfortunately, we do need to have a bit of time for questions, so I am going to open the floor to questions. So if anyone does have a question, please put it in the chat. While people write their questions, I'm going to start us off with one which was sent in earlier today. And this concerns Moreton Hall Detention Centre. For those who don't know, this is one of the detention centres in the UK, which, I mean, the conditions in all detention centres are bad. Some say Morton Hall was slightly better. I'll let the critics decide. But this detention centre was closed recently, and it's been reported that detainees there have been moved to other centres, and I quote, before changes are introduced next year. Does the panel anticipate what changes might be made, if any? It's quite a vague quote that was found, but apparently the Home Office has stated that, you know, changes might be made. Do you think there will be any? I'll let you go first, Adam.
Well, so the population of the immigration state is much lower following COVID, but it was already lower than it had been years before as a result of Windrush. So there has been a kind of, I suppose, a gradual decline in the number of people who are being detained. I don't know whether or not the decision to close Morton Hall was in response to that. I think there's a pretty there's a lot of anxiety about Brexit, obviously, and how that's going to affect things and leave people vulnerable to detention. I mean, it's my personal view that sort of the water's moving so much and things are so volatile. It's very difficult to predict how the Home Office is going to approach detention in the future.
Okay, great. I really like this next question from Catherine, who has asked, how has the Home Secretary's tirade against activist lawyers affected BID's work? Really great question. I suppose, Pierre, you were talking about the many lawyers that BID has on their list of representing individuals and also in strategic litigation context. What do you think in answer to Catherine's question? He's on mute.
Apologies, I missed the question because I was interrupted. I don't know if you saw me frantically going like that to my phone. Could you ask me the question again?
So Catherine has asked, how has the Home Secretary's tirade against activist lawyers affected BID's work?
I think, I mean, it's a typical, it's typical rhetoric that we're used to facing. And I think being an activist lawyer is certainly better than being an inactive lawyer. And I think an inactive lawyer who's doing their job would not really be doing their job. I mean, it's just extraordinary to hear that language. And the other thing is, I mean, the worrying thing, to be honest, is not so much the attacks on the lawyers, it's where that's going to go. And where that's going to go, it seems to me, from other rhetoric we've heard from the minister and from Boris Johnson, when they talk about changing laws, is that I think they're talking about changing access to the law. And one of the biggest, their main gripes is not the fact that that lawyers do a bad job. That's completely disingenuous. It is that lawyers are found by the courts to be doing a good job by making the correct arguments. And so what the government seems to be thinking, and have done this repeatedly in recent years, is they're looking at obstacles, creating further obstacles to people being able to access the law. So judicial review, which is one of the main challenges of unlawful detention, seems to be the target that they're looking at to try and restrict people's access to making challenges on unlawful detention or unlawful deportations. I think that they're going to have a very big battle on that to try and get that through Parliament. And certainly it will have an extremely negative effect on the UK's international reputation, which I think has taken a battering recently, but to you know, especially as they've created obstacles in terms of people being able to access legal aid easily, in terms of lawyers being willing to take cases forward because of the cost risks they may face. I mean, all these challenges that are being brought forward by politicians seems to me to be part of just the overall agenda. So when Priti Patel and Boris Johnson say nasty things about us, we can only rest assured that we're doing a good job. Yeah.
I think Celia has a comment. Shanze?
Yes, I've done it. I just want to add to that. I think our 4 lawyers would say, fine, we're activist lawyers, absolutely. You know, we'd see that as a badge of honor. But I think the other part of that quote was about activist lawyers abusing the law. And if anyone's abusing the law, you only have to look at the facts from last year as to how much the Home Office paid out in compensation for unlawful detention, which was 14.2 million. So
Yeah.
who was breaking the law?
That's
And
it.
then the other thing to say on that is also the denial, Pierre touched on it, the denial of access to justice, because there's no legal aid for the vast majority of immigration cases anymore. And so you have a situation where the Home Office is always represented, but other people aren't, because they can't afford a lawyer and they have to represent themselves. And if you're talking about deportation cases, that is life or death.
Okay, well, that's definitely a strong ending to that question. Another question we've got, I think we've only really got time for this last one, is do you see gender or age bias when it comes to detainees? I suppose, Adam, perhaps you would.
So Celia mentioned about you're not really supposed to detain, well, you can't detain unaccompanied asylum-seeking children, and there's time limits on children in families. Also, if you're older than 70, there's kind of adults at risk policies which work around that. There are certainly a lot more men detained than there are women, but I don't think that's necessarily the Home Office sort of being sexist. I think it probably is the case that there's a lot more male immigrants than there are female immigrants, and also a lot of immigration, or a number of immigration detainees anyway, have accumulated criminal offences, and we know that sort of men accumulate more offences than women. So I mean, the answer is you see more men in detention than women. You shouldn't see children at all, or people that are very old.
Great, thanks for that. I think we have time for one more question, which is the term foreign criminals, or the acronym FNO, which is foreign national, is used to stigmatize people with previous convictions, regardless of the specific history of offending. So yeah, foreign national offenders. Does BID think there is a preferable alternative?
Yeah.
Well, we think it's offensive as well. Sorry, 2 of us talking. We think it's offensive as well, because it just puts someone in a category immediately from which they can't escape. And we used to say former foreign national offenders, or foreign national ex-offenders. But I don't think any of those terms really are appropriate at all, because they're used to divide. And I think we should never sort of get caught up in this good migrant, bad migrant dichotomy, because, you know, it's a way that seeks to divide, and we must resist that kind of language at all costs, I think.
I think Catherine Hurley's just used the correct word, which is people. And so saying people in immigration detention is, I think, what I try to do. It's a long way of saying it, though. And acronyms are unfortunately part of common parlance and easy to understand. We all, in immigration law at least, and often in politics, know what an FNO is, a foreign national offender. And that's the way, it's not what we want to use. So where we can, I think we should be saying people in immigration detention. If I could just add a little aside, because BID is also writing and taking to task the Minister, the Undersecretary of State, Chris Phillips, comments in a letter to an MP where he refers to people in detention as being foreign national offenders, including rapists, murderers, and he doesn't say other lowlifes, but that's what he sort of means. And we've written back pointing out that our recent research during COVID-19, which relates to people, we looked at why were people granted bail in so many cases, and why was the Home Office insisting on detaining them, and what were they arguing? And in only 9 cases did the Home Office argue that people were at high risk of harm, and the evidence was found wanting in nearly all the cases that we looked at and that we've been dealing with. So the assertions that the Home Office makes and government ministers make, by tarnishing everyone and by really trying to engender or encourage hate of certain types of migrants, and by causing a misconceived perception of migrants, I think is something that we're trying to tackle at BID by showing the evidence that that the Home Office findings or assertions are ill-founded, not based on evidence.
I think that answers that question pretty well, and unfortunately we have overrun. So if anyone does have further questions, you can send it in an email to our NNM email address, which Shanze will put in the chat function now or in a moment, and we'll endeavour to potentially answer them in the future. But I see that time is of the essence. So I will conclude by just sharing some information about BID. These are some ways of supporting BID in whatever form you can. Obviously, if you can follow them on social media, that's fantastic. Keep sharing the stories that they put up, the campaigns that they're working on. That exposure really will help to lobby policy change. If anyone needs to use the advice line, it's open Mondays to Thursdays, 10 a.m. to 12, and sign up to their mailing list as well. You'll read loads of interesting stuff on there, and it's really informative. So with that kind of little keep in touch information, I will